And we are back, and we are now going to cover the use of warrants and in arrests, okay? And we're going to kind of go through the difference between what a capias is, which isn't written in here, but I'm very, very, very familiar with what a capias is, versus an actual warrant, okay? And I think this will delve into a valid warrant versus an invalid warrant and what is required of an actual warrant. A warrant is a check, and a capias is much different than a warrant, okay? The use of a warrant in an arrest. The requirement for warrants and the seizure of persons or property is an affirmation of common law principle. The declaration in our Constitution prescribes the modes in which they are to issue, reflects the inherent of the use of the so-called general warrants, whereby easy and arbitrary arrest and seizures were made. Despite such declaration for the security of liberty, privacy, and property, history shows that the executive department has long tendencies to disregard and violate them, as revealed by the U.S. Supreme Court. Though the policies are honest and their aims worthy, history shows they are not appropriate guardians of the privacy which the 14th Amendment, which the Fourth Amendment protects. While the Fourth Amendment has been badly violated, we find that the due process of law provisions is virtually ignored when it comes to warrants. For the most part, it is the due process provisions which prescribe the actual requirements of a warrant for all arrests except where public security allows a warrantless arrest. A warrant to be in the possession of the arresting officer. Now, I see a lot of times where people are approached on YouTube, we got a warrant for your arrest. And they say, well, can you produce it? No. It's back in our office. Well, then I suggest you take your happy ass back down there and get that son bitch, because until you bring that warrant here, it's all just hearsay. All right, this would constitute a false arrest. You better bring your documentation, sonny boy, or take your happy ass back to your department. And I've even caught myself up in that before, where they've said, oh, we got a warrant for your arrest. It's back at the office. Well, fuck you. Go get your warrant. All right. A warrant of arrest is a written order issued by a court or a magistrate directed to a peace officer or to a specified private person, commanding him to arrest a named person. It is regarded as fundamental law that where one cannot arrest without a warrant, a warrant must, not can be, must be acquired and be in the actual possession of the one making the arrest. Otherwise, he is not protected by it. The requirement of having the warrant for arrest in actual possession is the common law rule and thus is part of the due process of law, as it is a procedure which deprives a citizen of his liberty. In a case where a policeman, by direction of the sheriff, arrested an individual pursuant to a warrant, it was claimed that the arrest was unlawful, constituting false arrest and false imprisonment, since the sheriff retained the possession of the warrant in his office. The Supreme Court of North Carolina held that the overwhelming weight of authority for misdemeanor charges is that the officer must have the warrant in his possession. The court stated the following. In 6 Corpus Juris Secundum Arrest, subsection 4, page 576, ETSEQ, we find the general rule stated as follows. The warrant must, at the time of the arrest, be in the possession of and with the person purporting to act thereunder, or of one with whom he is acting in conjunction. Accordingly, where the warrant is at the officer's house, some distance from the scene of the arrest, or in the hands of another who is not at the scene of the arrest, or in the central office of a city detective bureau, the arrest is unlawful. Very important. Since there was no felony or breach of the peace committed in the presence of the policeman, his arrest was deemed illegal despite the fact that there was a valid warrant for the individual's arrest. Since it was with the sheriff who was in another town, the court also said that the good faith of the policeman did not affect the unlawfulness of the arrest. A Mississippi case involved a warrant that was issued for the arrest of Bill Smith on a reckless driving charge. Under the sheriff's instruction, a deputy went to the Smith's home to arrest him while the warrant remained in the sheriff's office. Smith asked to see the warrant for his arrest. The deputy replied he did not have it with him, but that it was at the sheriff's office and Smith could see it when they arrived there. However, Smith said he would have to see the warrant before he would submit to an arrest. Smith resisted the arrest. The sheriff was called out, but came without the warrant. Smith again resisted, but was forcibly taken to jail. The state Supreme Court held that the arrest was unlawful. Under the great weight of the authority, an officer making an arrest for a misdemeanor not committed in the presence must have the warrant for such arrest in his actual constructive possession if the arrest is to be lawful. In a criminal case involving a violation of a lien, a policeman was given a warrant for the arrest of a man named Shaw. He drove to Shaw's house in a buggy. He left the warrant in the buggy, being some 150 yards from the house. The officer went into the house and put hands on Shaw's shoulder and told him that he had a warrant out for his arrest and he was considered to be under arrest at this time. Shaw asked what for. The officer replied for disposing of property under lien, and that Mr. Bradham had sworn out the warrant. Shaw said, I am not going to. He resisted the arrest and claimed at trial that the arrest was not valid as at the time of the arrest, the officer had not actual possession of the warrant. The state Supreme Court held that the warrant was, in fact, in the officer's possession. The authorities agree that in the case of a misdemeanor not committed in the presence of the officer and for which he cannot lawfully arrest without a warrant, the officer should have a warrant in his actual possession at the time of making the arrest. It was not necessary that he should have the warrant in his hand or on his in his pocket at the time of making the arrest. Actual possession of it does not mean that. The rule is satisfied if the officer has such possession of the warrant that he can produce it with reasonable promptness on demand. The question of what constitutes possession of the warrant has often been debated, but it is obvious that it must be so close at hand as to show it upon request. Thus, it need not be said that the warrant must in all cases be directly in the hands of the arresting officer. This would be too narrow of an technical view of the law and one not based on substantial grounds. One's reason for actual possession is to show the authority for the arrest. Another is to display or read the warrant, and since this is to be done promptly, the possession must exist. Thus, the warrant must be in possession but not necessarily in hand, as the Federal Circuit Court of Appeals has stated. The officer who seeks to arrest by virtue of a warrant must have the warrant in his possession at the time of the arrest. We need not undertake to define exactly what is meant by in his possession. Of course, it does not necessarily mean that the warrant shall be actually in his hand. Where a warrant was directed to all police officers and exhibited to the two officers but was kept in the police station, the warrant was not sufficiently in the possession of the two officers to sustain an arrest by them. In the rather famous and landmark case of Crosswhite versus Barnes, a warrant for arrest of Miss Barnes was issued by a justice for a misdemeanor and placed in the hands of W.T. Crosswhite, chief of police. Crosswhite, along with the police sergeant, set out to execute the warrant, but left the warrant of arrest in his desk at the courthouse. When the officers first saw Miss Barnes, she was driving down State Street in her automobile. The police turned their car in front of Miss Barnes' car to stop her. One officer opened her car door and took hold of her by her arm and said, "Get in my car." She refused to and told the police she would not go anywhere without her husband. The policeman said, "We want you, not your husband." She asked the officer to show her the warrant. Miss Crosswhite said he did not have to do so. Mr. Crosswhite said he did not have to do so. Sorry, it's a little blurry. And said that you are going to the courthouse. The argument continued, ending in Miss Barnes being forcibly taken to the courthouse. Miss Barnes brought an action against Crosswhite and the other policemen for illegally arresting and assaulting and battering her. The police were found guilty, and on appeal, the Supreme Court of Appeals of Virginia affirmed the conviction and, in a very authoritative decision, stated, the textbooks generally state, and many cases hold, that it is necessary not only that a warrant of arrest should have been issued, but that the officer making the arrest shall have it with him and show it upon request. In Belize criminal procedures or pleadings and PR, subsection 18, it said, and an officer arresting on a warrant must have the warrant with him and must show it upon request. In 1 Bish New Crime Procedures, subsection 190, it said, to justify an arrest under a warrant, the officer must have it in his possession, and if though delivered to him, he leaves it at his office or station house, it will not protect him. And 2R.C.L. ruling case law 465 subsection 23, speaking of misdemeanors not committed in the presence of an officer, it said the officer should have the warrant in his actual possession in order to justify the arrest, and if he does not have it, although it has been duly issued, an officer making an arrest may not be protected by it. The court also referred to and relied upon a previous case in Virginia, the case of Moscow versus the Commonwealth, in which a policeman undertook to arrest Moscow for a past misdemeanor without a warrant, and Moscow shot and killed him. He was convicted of murder, and in the appeals court, the court reversed the conviction, stating, indeed, not only must there be a warrant in the class of a case last mentioned misdemeanor, but to justify the arrest, the officer must have the warrant with him at the time. Since a warrant must be in one's possession to arrest, a sheriff has no authority to send deputies to one place to make an arrest without a warrant, while he goes to another for the same purpose with the warrant. Nor can he send his deputies into one town while he gives pursuit in another. Under the ancient practice of hue and cry before warrants were issued, this might be done in the pursuit of felons, but no hue and cry could be raised for a misdemeanor. We think it clear that in this case of misdemeanor, the sheriff must be present, either in sight or hearing, directing the arrest, to justify a person not armed with a warrant to make the arrest. In Georgia case, a warrant was issued for the arrest of Shaw, charging him with a misdemeanor. The warrant was directed to any sheriff, deputy, coroner, or constable of the state. When the constable tried to arrest Shaw at his home, a friend named Adam interposed and asked the constable if he had the warrant for Shaw. The officer replied that he had it at his home, but not with him. Adams thus prevented the arrest of Shaw and liberated him from the custody of the constable. Adams was charged with interfering with the arrest. The Supreme Court of Georgia held that Adams was not guilty of any offense, since Shaw was not legally in the custody of the officer by virtue of a lawful arrest. The constable had no authority to arrest except under the warrant, which he did not have in his possession. The court held whenever a warrant has been issued to arrest a person charged with an offense in respect of which he cannot be apprehended without a warrant, the police officers must have the warrant in his possession at the time when he executes it. If he has not, the arrest will be illegal. Later, the court upheld this case under a similar situation where a warrant had actually been issued for an arrest, but the warrant was in the hands of the sheriff a number of miles away from where the arrest took place. The arrest was not lawful as the officer making the arrest had not been in possession of the warrant. In many cases, unlawful arrests have occurred where an officer receives some sort of communication from another jurisdiction or central office that a warrant exists for the arrest of a particular individual. The officer relying on such information and making an arrest upon it is liable for false imprisonment as he arrested without a warrant in his possession. One treatise says, in a case where the officer of one city, county, or district telephones to officers of another city, county, or district to make an arrest of a party with the last mentioned city, county, or district, it affords the officer attempting to carry out the instructions no protection and the arrest is illegal, unless such officer would have a right to arrest without warrant. Thus, where an officer was informed by a letter written by the chief of police of a city in another state that a certain person has absconded with funds belonging to a benevolent association, the officer was liable in damages for arrest of this person without a warrant. The fact that the person knows that a warrant for his arrest is outstanding does not eliminate the need for possession of the warrant in making the arrest. In Anderson's treatise on sheriffs, it states, where arrest is being made under the authority of a warrant, the officer attempting to execute the same and arrest the party named therein must be in possession of said warrant, or it affords him no protection. The necessity for the possession of the warrant is not relaxed by reason of the fact that the party to be arrested knows of the issuance of the existence of such warrant for his arrest. Thus, where an arrest is made without having the warrant in the possession of the arresting officer, such an arrest is treated as though it were made without a warrant. Warrant to be sworn upon arrest. Coupled with the requirements to have the warrant in possession when making an arrest, is the requirement to show or display the warrant to the arrested person. Where an arrest is claimed to be made under the authority of a warrant, it is the duty of the one making the arrest to show the warrant and read it to the one being arrested, especially when he requires to see it or demands to know the nature and the cause of the arrest. He need not submit if this is not done. In cases of Smith versus State, Supra, the Supreme Court of Mississippi not only said that the warrant must be in the actual possession of the officer, but he must show it to the accused if requested to do so. In State versus Shaw, Supra, the court said that the reason that a warrant is to be in the actual possession of the arresting officer is that, if demanded, he must procure and produce the warrant and read it to the accused, that he may know by what authority and for what cause he is deprived of his liberty. In Crosswhite versus Barnes, Supra, it was stated that the arresting officer must have the warrant with him and must show it on request, and cited a number of authorities in support of this, such as the following. In the annotator's summary of a note in 42 L period R period A period at page 682, it is said an accused person, if he demands it, is entitled to have the warrant for his arrest shown to him at the time of arrest. See also 51 L period R period A period 211. In an earlier case in New York, a special deputy was charged with the duty to serve a warrant for larceny issued by a justice of the peace. The person arrested required the deputy to show him the warrant before he would submit to the arrest. The deputy did not do so, and the man resisted, and the deputy beat him. At trial, the judge charged the jury that if the defendant did not show the warrant to the man, he was a trespasser. The jury found the verdict in the favor of the man arrested. The Supreme Court of New York upheld the verdict, stating, a special deputy is bound to show his warrant if requested to do so, and if he omit, the party against who the warrant is may resist an arrest, and the warrant under such circumstances is no protection against an action for an assault, battery, and false imprisonment. Failure to show or display a warrant when a warrant for an arrest allegedly exists, the arrest becomes illegal. On this matter, the Supreme Court of Georgia stated in Gallard versus Laxton, 2 Best and S periods 363, 9 Cox, C period 127, it was held that in a case in which a lawful arrest could not be made except under a warrant, the arresting officer were bound to have the warrant ready to be procured and produced if required. That an arrest in such a case by police officers who did not have the warrant in their possession at the time was illegal. Thus, the primary reason for an officer to have the warrant in his possession when making the arrest under the warrant is so that it can be shown to the one arrested, so that he knows the authority by which he is being deprived of his liberty. This was so held by the Supreme Court of Texas. It ought not to be denied that the law contemplates that the warrant directing the arrest of a person charged with the crime will be in the possession of the officer when he make the arrest under it, for he is required to exhibit it if called upon to do so. And this is based on a wise public policy, one purpose of which is that the officer may have to exhibit such evidence of his authority to make the arrest as will be deemed sufficient to make from the person, to take from the person whose arrest is commanded all right to question the authority of the officer. The argument that the officer is free to arrest because there is a warrant outstanding, and nullified by the requirements of the law that one arresting under a warrant must show it if requested to do so, which is manifestly impossible unless he has the warrant in his possession. An officer arresting for taxes due on a tax warrant was held to be a trespasser where he had not the warrant with him at the time of the arrest, thus failing to show it to the one arrested. The court unanimously held, we think that the authorities are all to the effect that the officer making the arrest must be in the situation to show, if required, the authority under which he is acting. It is the legal right of the citizen when arrested that such shall be the situation, and therefore, when such situation does not exist, the arrest is a legal wrong. An arrest warrant is to be shown to the accused, for he has a right to see it, to see if it is valid warrant. Speaking on the topic, production of warrant, one law textbook states, every person relying upon a warrant in making an arrest should read it if requested so to do. Where a warrant is necessary, but the person making the arrest refuses to exhibit it, called upon to do so, he may forfeit the protection which it otherwise would afford him. In the annotation of the American Law Reports, Volume 40, page 62, a review was given on the topic, necessity of showing warrant upon making arrest under warrant. The report clearly showed many other cases that held that the officer must show the warrant upon the request stated. The weight of the authority now, however, seems to support the position that an officer making an arrest under a warrant should show the warrant if requested to do so, and in some jurisdiction he is expressly required by statute to do so. The enactment of a statute that the warrant is to be shown upon arrest is but declaratory of the due process procedure that must be followed in an arrest. Thus, no statute is needed, and where it exists, it is merely redundant in nature. The annotated report did speak of some authorities where it appeared that the failure of showing the warrant was allowed. It stated in the review that in some cases a regular officer does not need to show his warrant before making an arrest thereunder. Such cases involve the question of whether the officer is known or unknown to the person being arrested. In some cases is what it was stated that when the officer is known, he need not show the warrant before the arrest, but must show it after the arrest. And where the officer is unknown, he is to show the warrant before the arrest. Other cases where it appeared that the showing of the warrant was not needed is where resistance is offered or threatened before the person asked to see the warrant. The argument that a known officer need not display his warrant at all, or that in lieu of displaying it need only state the authority under which he is acting, is not justified by the principles for why warrants are needed in the first place. Such an argument could completely take away most of the safeguards of liberty, which the requirements for the warrant was established. The true law on the matter requires the officer to possess and display the warrant whether he is known or not, and in addition to his stating the nature and the cause for the arrest. The generally recognized rule, however, sustained by the weight of authority, and particularly in the case of misdemeanors, requires the officer to exhibit the warrant of arrest before the arrest is made, unless there is some resistance. In an English case cited in 40A period L period R period annotated, it was held that Where a constable making an arrest did not have the warrant with him, he was not justified in making the arrest. The court said, "We have already expressed our opinion that if requested, the officer are bound to produce the warrant, and if so, the keeping in custody after request and noncompliance would not be legal, and it can hardly be contended that the arrest itself could be legal." So false imprisonment, false incarceration. In an older English case, it was said that the doctrine that an officer needed to show his warrant was a dangerous doctrine. That court also stated, "I do not think that the person is to take it for granted that another who says he has a warrant against him without producing it speaks truth. It is very important that in all cases where an arrest is made by virtue of a warrant, the warrant is demanded, at least should be produced." The reason for the duty of an officer arresting a party by virtue of a warrant was declared in Com versus Cooley, 6 Gray, Massachusetts, 350 in 1856, as being to explain the cause for which he makes the arrest. To state that the nature and the substance of the process which gives him the authority which he professes to exercise, and if it is demanded of him to produce and procure and exhibit it to his prisoner for his per usual, that he may have no excuse for resistance. The court added that these obvious successive steps, which cannot all occur at the same time, at the same instance of time. In a New York case, a man was convicted for resisting a police officer who attempted to arrest him for a past misdemeanor, the warrant being at the office. His conviction was reversed because it was the duty of the officer at the time of the arrest to disclose to the defendant his authority and the process under which he was to be arrested. The court said that the state statute was the same as the common law doctrine on this matter. If the officer must show the warrant, if required, then it is plain that it must be in his actual possession. It would be absurd to construe this to mean that after making the arrest, the officer must, if required, take the defendant to some other place and there show him the warrant. It is clear that the warrant must at the time of arrest be shown, not at a later date or time. In State versus Peeney, 42 ME period 384, 1856, the court is discussing authorities, stated that it is very important in all cases where an arrest has been made by virtue of a warrant that the warrant should be produced if demanded. In Sullivan versus Com, 106 Pennsylvania, 369, 5 a.m., Crime Report 41, 1884, the court is explaining that the duty of one making an arrest said, "It is doubtless that the duty of an officer who executes a warrant of arrest to state that the nature and substance of the process which gives him the authority he possesses to exercise, and if it is demanded to exhibit his warrant, that the party arrested may have no excuse for resistance." In Jones versus State, 114 Georgia, 7939 S.E. 861, 901, the state Supreme Court held that a constable was not justified in attempting to arrest the defendant under a warrant which was in the sheriff's hands. The court said that it was the duty of an officer who attempts to make an arrest to exhibit the warrant if he has one. Invalid and unlawful warrants. A warrant must have certain requisites in order to render it valid and available as a defense. Many unlawful arrests have been made due to warrants failing to meet such requisites. Whenever a warrant is invalid on its face, or where it is only a summons, the officer arresting the defendant will be liable in damages. A prima facie invalid warrant will be regarded as no warrant, and the officer making the arrest by a void or invalid warrant is not protected by it. Process that is void on its face is no protection to the officer who executes it. If a warrant, order, or writ of possession shows lack of jurisdiction of the court, the officer is not protected in serving it. In fact, in so doing, he becomes a trespasser. A constable justifying an imprisonment under the warrant must show that the warrant on its face is legal and that the magistrate had jurisdiction of the subject matter. Both a proper subject matter jurisdiction and geographical jurisdiction are necessary for a proper valid warrant. It is generally held that where the court has no jurisdiction, the officer executing a warrant will be liable in damages. The question of jurisdiction can be raised at any time, and since neither consent nor waiver can give jurisdiction, the court will not proceed where it appears that from the record that it has no authority. A warrant for the arrest of an alleged fugitive was void because the complaint did not state that the original charges has been made upon oath or made to a court, and it afforded no protection to the constable. The requirements of what a warrant should contain depends primarily on constitutional mandates, due process practices, and the common law principles. The common law requires that an arrest made on a warrant be issued only after a formal charge is made under oath. Thus, no arrest is valid unless based upon a sworn affidavit. An affidavit that does not appear to have been sworn before any judicial officer, and a warrant signed by only an officer who made the arrest and not dated or authenticated, afforded no lawful authority for the arrest and detention of an accused. Another obvious requirement of a warrant that would make it void on its face is if it is not signed by the magistrate or justice of the peace. It has become a practice in some areas to have warrants rubber stamped with the judge's name, this stamping being done by some clerk or administrative employee. This blatantly unlawful practice has been adopted for convenience sake, which is the most common reason of excuse governments use to transcend constitutional limitations. Such limitations were designed to make the government follow certain established procedures and thus make things difficult in order to deprive a citizen of his liberty or property. A rubber stamp warrant is invalid on its face as it is not signed by the judicial officer. The authorization for a warrant requires not only judicial authority, but is to be done by one who is learned in the law to determine if probable cause exists to issue the warrant. In Minnesota, the state Supreme Court held that a statute permitting clerks and deputy clerks of the county municipal court to receive complaints and issue a warrant in prosecution under municipal ordinances is unconstitutional. The court said, the United States Supreme Court has considered and disposed of a related problem in Karma versus Municipal Court. I hear you clucking, little spoon. I'll be there. 387 U.S. 523 541. The majority in Karma nevertheless stressed that the need for individual review by a neutral magistrate to avoid the issuance of rubber stamp warrants. Since the taking of an affidavit in a criminal proceeding imposes a duty of a judicial nature, an affidavit taken before a clerk or prosecuting attorney is not sufficient as a basis for the issuance of a warrant. A warrant is regarded as insufficient and thus void if, on its face, it fails to state facts sufficient to constitute a crime. Also, a designation or description of the offense should be written in the warrant, but need not be specified with the same technical strictness that is required in an indictment. The rule on sufficiency of a charge on which a warrant can issue is stated as follows. The complaint or charge on which a warrant is issued must set forth the facts constituting the offense on the knowledge of the person making the complaint, and if he does not know them, other witnesses must be examined who do know them, and no person can be arrested on the mere belief of the person making the complaint. Okay, it takes two or more plus the aggrieved. All right. A warrant is issued for a matter that is not a criminal offense is no justification for a constable who arrests upon it. A person cannot be lawfully arrested by a sheriff acting under a copy of a court order or warrant in the form required. Such copy is not valid. Now, I gotta run. I gotta go raise some ruckus in a courthouse. I'll see you guys a little bit later.